Hi, everyone. Thank you for joining us today for Constangy's webinar, 2024 in Review, Massachusetts Labor and Employment Law Highlights. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave some time to answer your questions. This program is approved for Sherman HRCI credit. We'll be sharing those codes at the end of the presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenters, Monica and Sasha.
Thanks so much, and thanks everyone for joining us today. My name is Sasha Thaler. I'm a partner here in our Boston office, and I'm also co-chair of our Workplace Investigations Practice Group. My practice centers on employment law, counseling, litigation, and sort of everything in between, and also serving on investigations in the workplace and beyond. And I'm joined today by my colleague, Monica Towle, who will introduce yourselves.
Hi, everyone. My name is Monica Towle. I am also located in our Boston, Massachusetts office. My practice focuses on employment counseling and litigation as well. And I look forward to talking to you about the last year here in Massachusetts and the updates in employment law.
Great. So just a quick overview of what we plan to talk about during our session. As you can see on our first slide here, we have sort of 4 categories of updates we wanted to share with everyone. The results of ballot measures that were relevant for employment law, and just a little bit of thinking about where things may lead in the future. Some discussion of statutory updates, some key cases. We will try to make them as interesting and applicable to your actual business as we can, and then a few other miscellaneous developments. So first up are ballot measures, and Monica will walk you through those.
All right, so there were 2 ballot measures in Massachusetts this year that we wanted to discuss that focused on employment-related issues. The first is the tipped minimum wage increase that was proposed. So this measure actually failed, but Massachusetts voters rejected a proposal that would have gradually increased the pay for tipped workers. The ballot measure would have increased the minimum wage for tip workers from $6.75 to $9.60 in 2025 until it gradually reached the full minimum wage. That measure failed, as I said. We still have the same minimum wage in place. This is mainly just a reminder that the minimum wage is going to stay the same, and to make sure that you understand the rules that are outlining minimum wage, that the employer has to make up the difference if the tips don't bring the employee to the minimum wage, and also that there were some federal changes this last year in Massachusetts as well regarding tipped workers. So the Department of Labor had a tip credit rule that's from 2021, and that was actually struck down this year. The rule set guidelines that limited the amount of time that tipped employees could spend on non-tipped type work, work that did not produce tips. And this established what was known as the 80-20 rule for tipped employees. This was struck down on August 23rd. So that rule is no longer in place. Now, although the Department of Labor rule was struck down, employers should still pay attention to the somewhat different rules in Massachusetts surrounding tipped employees. That's who can receive a tip, who can participate in a tip pool, and how much of a tip credit can be taken. All of these are different from federal law under the Massachusetts Tips Act. So that is the first ballot measure we wanted to discuss. The next ballot measure is about the unionization of rideshare. This measure actually did pass. So this allows for the unionization of rideshare drivers while still being classified as independent contractors. And this is first of its kind. We will see what comes with that. Once the question becomes law in January, the union organizers for the specific union will need 25% approval of the rideshare drivers, which is roughly 80,000 drivers across Massachusetts, to go to the next step to allow them to conduct a formal card check. So there's a lot of steps along the way that we could go into, but mainly for the purpose of this presentation, I just wanted to bring up that this is a very unique situation. There are a lot of hurdles along the way, and we don't foresee this having an impact on independent contractors in other fields. This is very unique to rideshare and was specifically passed for this limited group of contractors.
Yeah, that's right. And actually, Monica, before you go on, I just wanted to sort of add on a little bit to that. I mean, certainly, another aspect of the independent contractor situation in Massachusetts that some employers may be aware of, and that actually we will touch on a little bit in the portion where we talk about the recent case law. But you know, that there is this question of who can even be classified as an independent contractor. So what's interesting about this ballot measure is that it is sort of trying to carve this middle path between employees and contractors. And to Monica's point, you know, it is very limited to this industry, but it's an interesting concept that's being sort of put forward. And it will be interesting to see whether there might be some interest in changing how these various rules apply, even outside of sort of these very of the moment industries, right? Like rideshare, of course, they seem to be here to stay. And the question, and so is the gig economy. And the question is, you know, will there be some movement away from this sort of very strict view that Massachusetts law has of independent contractor classification, because there seems to be this interest in creating this other category of folks who are both independent contractors but potentially in a union. So yeah, thanks for flagging that, Monica. I think it's a very interesting development. Okay, so next we wanted to chat through a couple of statutes that came up in 2024 and that will have implications for employers, certainly in 2025. And the first big one, I think, is the pay transparency and pay data reporting statute. So the statute passed, and it has basically two important segments. One is it will require employers who are currently subject to EEO-1 reporting requirements to submit reports to the state as well. And the other will be for a requirement starting in October to disclose certain pay information to prospective employees. So focusing first on the reporting, couple things to keep in mind for this. So it does only apply to employers that already have the EEO-1 or EEO, you know, other suffixes reporting requirements. In other words, it only applies to those with 100 employees. It does, however, apply specifically in Massachusetts if you have even one Massachusetts employee, right? You'll need to be making this report. And the current requirement, the way it's phrased, is that there is a requirement to report demographic and pay data by these specific categories, but that the EEO-1 report that you're otherwise completing and submitting for the federal reporting requirement will suffice. So the interesting thing here is it's not clear to me how those two match up, and we'll see whether that requirement stays. In other words, if Massachusetts is looking for pay data, that's actually not something that has to be reported to the feds. I'm not sure how they're going to get around this, but so stay tuned on that, but do keep an eye out for any updates on this in February. It's possible that February 1 may be a weekend or holiday. Yeah, February 1 is a Saturday, so it's technically will be the February 1 of every year, but I think in this particular go around, it may be a couple of days later, so February 3rd. But in any case, keep an eye on this in January, and we'll certainly let people, let our clients and contacts know if there's any development on what the requirement is here. Now looking at the next or the other portion of the statute, which is the pay transparency requirements, this is certainly Massachusetts jumping on a trend that has been developing across a number of different states to require proactive information to be provided to applicants and employees. So the basic requirement is that starting October 29th of 2025, it's a little bit of a strange date, but it has to do with when the statute was both signed and then when it became effective. But so October 29th of 2025, employers will have 3 situations in which they will need to provide information, including pay ranges for in a job posting, and we'll get in a second to what is a job posting. The second is to provide a pay range for somebody who's offered a promotion or transfer to a new position with different responsibilities. And the third will be, if requested, to provide a pay range for a particular position to anyone in that position or to an applicant for that position. And there's a couple of interesting sort of questions that remain unresolved given the way the statute is written, but there is also a requirement for the state to issue guidance or regulations on it. So hopefully before the October 29th sort of deadline, we will have a little bit more clarity what each of these means. But in the meantime, here's what we do know. So with respect to what is a pay range, the statute does say that it is the salary or hourly wage range that the employer reasonably and in good faith expects to pay for the position. And the key here are the annual salary or hourly wage and what you reasonably expect. In other words, it doesn't include things like bonuses, other benefits, equity, commissions, any of these other things. And it doesn't require you to be, 100% spot on with no potential deviation. It merely asks you to make a good faith effort to figure out what the range is. So a couple of things, right, employers will want to think about, even though the statute only requires providing that information, might you want to consider also adding information on things like bonuses and commissions and benefits and equity so that you don't inadvertently make it seem like the position is actually paid less than what it actually is. And then the other question that probably comes up for folks is, well, what counts as a job posting, right? And so the statute says it's something that you post that is for a particular and specific position. So to my mind, what that means is, if you just say, hey, we're hiring, right? If you have a LinkedIn post that says, looking to hire, right? That's probably not going to require you to then disclose the pay data of, everyone in the company. But if you have, an internet or a LinkedIn post that says, hey, we're looking for, a level 2 engineer, that might turn in, that might start looking like a particular and specific position, and you should at least consider, do we also need to post the pay ranges there? Of course, other question that comes up with all of this is, how do we figure out the pay ranges? And there are a couple of different ways to do it, but one thing you might consider is, a fairly comprehensive audit of what are you paying now and what are the positions that you have, so that going forward, when you do have to provide this information, you're not doing it on sort of an ad hoc basis. This also will have the benefit of exposing potential risks that your business may have in terms of pay equity requirements, right? So Massachusetts, a number of years ago, passed the Equal Pay Act, and what we call MEPA, that does require that there be equal pay for substantially similar positions, regardless of gender. And so considering what information you may need to have in your back pocket to comply with the pay transparency requirements may also have that added benefit of helping you ensure that you're complying with that pay equity. requirements. And then just one more quick note on this statute in particular as to the violations. The good news is, potential violations. The good news is there is no private right of action. So you're not going to see a slew of lawsuits from individuals claiming that they, were not provided pay data. And in particular, this is good news for folks that may otherwise be subject to, class action type of liability. But there will be complaints to the Attorney General. The Attorney General will investigate. And what we understand is there will be sort of a gradual series of increasing significance for, for what might be an employer might be liable for. So starting with, from as low as a warning to fines of up to even $25,000, which of course is, fairly significant if it adds up. So there will be a little bit of grace period postings sort of in two ways. One is that multiple postings within a 48-hour period for the same position won't count as separate violations if they're all non-compliant. But it's only 48 hours. And then also for the first 2 years, there will be a grace period if there's notice of a violation. Okay. And then, sorry, before we go on, Monica, I don't know if you wanted to jump in and add anything I might have missed in explaining this particular statute.
No, I think you did a great job.
Okay. And then just one more note on some statutes. News in the realm of statutes is the sick leave law in Massachusetts has been expanded to extend to physical or mental health needs related to pregnancy loss and related conditions. And that's again available, as is the sick time statute generally, for the employee and their spouse who's suffering from this. In my view, and Monica, let me know, let us all know if you have a different view of this. I'm not sure that this constitutes, a sea change in the way employees will be using the sick time law, not because it's not an issue to need to recover from these kinds of, life events, but because the sick time law in Massachusetts, at least, has a very low bar for being able to take the leave. And I suspect that employees may have been using sick time for these kinds of events already, right? Because, usually you if you're unwell or if you have a mental health issue, the employer is not and ought not to be asking you why, right? You just report that you have the need for sick time. And so long as the period is, reasonably, I believe it's shorter than 3 days, you're not going to be asked, and the employers aren't allowed to ask for documentation. So I suspect it won't necessarily mean a large change to what employers need to be thinking about in terms of sick time. But Monica, if you have a different experience or view, I think it would be important for folks to be aware.
Right. I agree. I think the other thing to focus on is that it is the employee and their spouse, and that it's not limited in the sense of pregnancy. It is also assisted reproduction, IVF, adoption, surrogacy. So it's not just limited to a medical condition that somebody may be having. So that's important to note as well. And like I said, the spouse might be the one that is taking leave in this situation. And so to have that specified may allow people to take more leave that they wouldn't have otherwise done. So that would be the situation where I could see it arising more.
Agreed. All right, I think that's what I had for statutes. So Monica, go ahead with our next section.
Yeah, so the next thing that we wanted to talk about were some of the key cases over the last year. There were obviously several cases developed in 2024 concerning labor and employment, but we pulled together 5 main cases to walk through with you today that each touch on different issues. So the first one that I wanted to discuss concerns retention bonuses and what constitutes a wage under the Massachusetts Wage Act. So Nunes versus Sinksort Incorporated, we have an appellate decision from September that came out. In this case, like I said, concerns retention bonuses. The plaintiff in this case was terminated due to a reduction in force prior to a second payment of a retention bonus. So the way that their employment agreement for their bonus set up their retention bonus, they had two series of payments. One happened while they were still employed, but there was a second payment scheduled after that reduction in force. And the court ultimately found that that bonus that was at issue in this litigation did not constitute wages. It was not a wage under the Wage Act. And this distinction is very important because of the penalties that are imposed for late payment. The second payment was actually paid to this employee after the complaint was filed, but at issue were some significant penalties that could happen. The Wage Act imposes strict liability on employers for late payments of wages. It also imposes treble damages and attorney's fees. So when dealing with a retention bonus not being a wage, instead this would be a standard breach of contract claim for compensable damages instead of all of these penalties that would typically be at issue and the heightened liability standard. Now, I will note that this case is currently on appeal at the SJC. Briefs were just filed in November, so we are monitoring to see what happens there. But right now, based on this, payments of retention bonuses are not categorized as wages. And so with that, I wanted to talk a little bit about the development of what is a wage right now under current law in Massachusetts. So we put together this chart that kind of explains what is a wage under the Wage Act. So obviously wages are salary, hourly pay, and then there's also holiday pay, vacation pay, and commissions that are due and payable. And that's only once it's definitely determined that they are payable. That's when they are wages, not wages unless by agreement. You could always make an agreement that they are wages. Right now include things such as unused sick time, discretionary bonuses, and then, like I said, the retention bonus, that's a new addition with this current case law. Severance pay, contributions to deferred compensation plans, and percent of profit incentive payments. Those are the different categories that we have cases that have already addressed and determined whether or not they're wages under the Wage Act. I don't know if, Sasha, you want to add anything on the wage issue before getting into your next case, which I believe goes over restrictive covenants?
Yeah, that's right. I guess my only comment on the wage issue would be, it's very interesting how this case law is developing, because on one hand, the courts in Massachusetts tend to read the Wage Act very strictly and very much in favor of employees. And yet, on the other hand, we do have a number of cases that have said certain kinds of, dollars that are paid, and indeed, something like a retention bonus or severance pay is often paid with taxes withheld. So it sort of feels like a wage, right? It acts like a wage. And yet, for the purposes of a Wage Act violation, and as Monica emphasized, the treble damages possibility, it is, at least for the moment, not considered a wage. I am very curious to see what the appeal turns out to give us as a definitive statement on this, because there's certainly some arguments for why it should be a wage. Great. So yeah, I will now switch gears a bit to talk about Neely, and this is another very important case, I think, for Massachusetts employers, but also one that is currently on appeal. So the state of the law as it is potentially a little bit temporary, but this involves the Massachusetts Non-Compete Agreements Act, sometimes called the MNAA. That became effective October 1st, 2018, another strange effective date. But it, as some employers will be aware, it created a number of restrictions on non-compete agreements with Massachusetts employees. So the statute itself talks about what kinds of agreements are subject to these kinds of restrictions and what aren't. And that was really one of the main parts of this case, was talking about what what kind of provision in an agreement puts it into the category of something that does have to comply with the statute and something that doesn't. So the situation in this case was that the employee had previously signed an agreement before October of 2018 that included an employee non-solicit. And then at the time of their separation, they were offered a separation agreement, and that was after October 1st of 2018. And in the separation agreement, there was also a provision that, said you'll get all, these various payments, but if you are in violation of your obligations, including your obligation to comply with the existing employee non-solicit provision, then you will forfeit the severance that you're being offered. So the interesting sort of outcome in this case is this Superior Court judge said that the original non-solicitation agreement, although it did not originally need to comply with the Massachusetts statute, because that statute doesn't have retroactive effect, because it was pulled into this separation agreement, and the separation agreement included a number of new obligations for both parties, it became something that was subject to the new statute. The employer, the defendant, had tried to argue that it was merely sort of reaffirming, right, and sort of continuing the existing non-solicit obligation, and so it didn't come in to the 2018 requirements. And the court said, no, the fact that you included new additional obligations for the parties means that it is a new agreement. And because this is a new agreement entered into after October 1st of 2018, it must, either comply with the statute or meet one of the exceptions. So that was sort of the first part. And then when the court was looking at whether it complied or met, one of the exceptions, well, actually, everybody agreed that it didn't comply. Right. So one of the requirements for non-compete in Massachusetts would be, making sure it's only limited to 1 year, making sure that there is a statement about what the consideration was that was given in exchange for the non-compete obligation, stating that the employee has a right to speak to an attorney, various sort of bells and whistles that have to be included. And the parties agree that this didn't have it. Why? Because the parties didn't, or at least the employer didn't think that it needed to comply, right? It was an employee non-solicit. And the reason they didn't think it needed to comply is because the statute says non-competition agreements do have to comply, and a list of types of agreements are not considered part of the definition of a non-compete agreement under the statute. And one of those things is a non-solicit. So the statute says non-competes have to comply, but non-solicits are not non-competes, so they don't have to comply. Except what this court said was, well, this wasn't just a non-solicit, it was actually a forfeiture for competition provision. And what the statute says is non-compete agreements include forfeiture for competition agreements. So the court said, because you were tying the non-solicit of employees to the concept that a violation would result in the employee losing their severance, and in fact having to disgorge some of the severance they'd already been paid, that became a forfeiture for competition agreement, which is like a non-compete, something that has to comply with the statute. And because it was entered into as a new agreement at the time of, at a time that was after October 1st of 2018, it had to comply, and it didn't. And the other interesting piece of it is the court also went on to say, and by the way, this also doesn't count as, it doesn't fit within one of the other exclusions, which is agreements entered into at the time of separation. So even though the employer had included a 7-day revocation period, which is one of the requirements for getting a non-compete to be excluded from the statute, if you enter into a non-compete at the time of separation, and so long as you provide a 7 business day revocation period, you don't have to comply with the other requirements of the statute. The court said, no, doesn't fit that exception either, because again, it is a forfeiture for competition clause. It is not a agreement at the time of separation that is excluded. it's a very interesting decision for a lot of reasons. I think a lot of employers probably have been thinking, hey, whatever deficiency I may have in my existing agreements, I can sort of fix it because I'm entering into it at the time of separation and I'm going to give the 7-day revocation period. Or maybe even I don't have to worry about this at all because all it is an employee non-solicit and that's clearly excluded. This court is saying, yes, if all you're doing is saying, here's your non-solicit, if you violate it, we'll file an injunction. But if you're saying, here's your non-solicit, if you violate it, not only might we file an injunction, but also we're going to take your severance pay back, then that brings it right back into the statute, which has to have all these other elements. So I know I said a lot about that, but it just strikes me as a truly really important case for folks to be aware of as they're thinking about what do you want to be doing with an employee that is departing and has been around long enough that they signed their agreement before October 1st of 2018, when none of us knew that these requirements were going to be in effect. Do you want to risk pulling this agreement into the purview of the new statute and potentially losing the restrictions that you may already have? All right, so Monica, unless you have anything else to add, I feel like I've already talked
absolutely.
much too long about
I was
it.
also surprised when reading this. It was a long opinion, a lot of different issues going on, but I was really surprised how they were able to pull the non-solicits into it. So I will be interested to see what happens as it works its way through appeal, and definitely one we should monitor and see what's going on. So. The next case that I wanted to discuss is an SJC case. So this is not on appeal. This is a full decision that we now have, Budge versus the Commonwealth. And this concerns Paid Family and Medical Leave Act and whether benefits can accrue while someone is on leave for PFMLA. So this was a particularly important issue for the state troopers in this case, who were bringing the claim. So they were trying to establish seniority and length of service credit for the time that they had been working as troopers. And they wanted to extend their seniority and their service credit for the time period while they were on leave. So they were also claiming for accrued vacation and sick time during their leave as well. And the SJC found that there is no guarantee of accrual of benefits during leave. So the PFMLA requires employees to be restored to a similar role with the same benefits, and it guarantees that leave will not result in loss of any prior accrued benefits, but that does not mean that those benefits continue while you're out on leave. So I think that gave a clear understanding of what to expect in these types of cases. Sasha, I don't know if there's anything you want to add from that case specifically.
Yeah, I think it's, I'm glad you raised it because I think it's an important issue and, you know, certainly employers can always be more generous than they need to be. So for example, if somebody's out for, you know, their 12 weeks or whatever it may be for a serious health condition, you may decide that you will continue to credit them with, let's say, their seniority. Yet, that is just being more generous than you need to be in the statute. And so at the same time, you could say, however, we're not going to let you accrue vacation or sick while you are not here performing any services. And it looks like employers now have the flexibility to, you know, do what they're able to do with the without sort of pulling in other requirements or obligations.
Absolutely. So now I think the next discussion will go into franchisees and employment classification, another SJC decision.
Exactly. And this is the one that I referenced near the beginning of our discussion, because this goes back to independent contractor status. The interesting thing about this case is it focuses on the very beginning of that statute rather than what we usually think about. So in Massachusetts, we have the independent contractor statute that says, you know, folks who are providing services are generally presumed to be employees unless all three of certain specified requirements are met. We often call that the ABC test for the three requirements, right? The interesting thing about this series of cases is it didn't jump to the ABC test, and it started sort of on the first sentence of, well, who is somebody who is performing a service for the employer? Because if the person or entity we're talking about isn't performing a service, then it doesn't matter whether the ABC prongs are met. They fall out of this statute entirely because they're not performing a service. So the issue here was whether 7-Eleven franchisees were performing a service, and in particular, those who have a business entity that that they're running by using the 7-Eleven brand. And what the Supreme Judicial Court said was that you need to consider whether an individual is in fact performing a service for the franchisor or not, or whether they're performing the service actually for their franchised entity. And that entity is performing a service. It can't be an independent contractor because it's not an individual. And the way you determine that is you look at a series of factors, right? So it's not based on the label. You can't just call somebody a franchisee and say, therefore, they're not an employee. You do want to look at a number of factors that will indicate that they're performing a service. And so some of the factors that the court referenced were things like the level of independence, right? Whether the control that's being exerted by the franchisor is more in the nature of ensuring that brand standards are met versus having employment type of control, whether there's actually any direct service at all, and the economic structure of the franchise model. So I think this was sort of probably elicited a sigh of relief from a number of employers or entities that use the franchise model to make them feel more comfortable that so long as they are in fact have contractual parameters that are consistent with a true franchise model, as opposed to sort of some sort of subterfuge for employment, then the SJC has now said that is okay. The franchise model can survive, it can exist as long as it's done the right way. Then what you're exercising is sort of your contractual right to engage a person or entity to sort of carry on your brand. And if the control you're exercising is more along supporting that rather than exerting employment control, then you're not within the independent contractor statute, which is fairly limited. Anything to add to that, Monica? I know you've got another case you wanted to get to.
Really just that it's a fact-based analysis, and it might change on case to case, but I think this gives us a lot of guidance of what to look for in the franchise situation, and that because of this finding, similar companies will probably have resolution there. But if the franchise set up a little bit differently than the 7-Elevens, then it's again going to be fact by fact. And there's not going to be necessarily one of these factors that will be the determination there. So there's a lot of different situations that you have to look at under this test. So the next case that I wanted to talk about is a case from the appeals court, Tran versus Jennings Road Management Corporation. And this looks at joint employers. And the Massachusetts Appeals Court broadly interpreted in this case what qualifies as a joint employer or joint employment for the purpose of liability. And in doing so, they applied a 4-factor test. And so I wanted to highlight what that 4-factor test was. In this case at issue, the plaintiff was held to be jointly employed by a car dealership who was her direct manager or direct employer, as well as its management company. And this was based on the specific facts of this case under a 4-factor test that was a totality of the circumstance test. So this is the framework now that is applied for joint employment. But again, it's a framework. So there's not one factor that is dispositive of the issue here. It's going to be a totality of the circumstance. And so although a wage claim is typically only viable against a direct employer. Here, the test, the totality of the circumstances was applied to see if the management company was actually a joint employer. And the court found that the management company was. And they seem to be compelled by the handbook and policies at issue. The handbook and policies for the employees were actually authored and administered by the management company, Jennings Road Management. So there was a lot in that case highlighting those handbooks and policies. So that seemed to be the fact that was most focused on under this framework. The biggest takeaway then from this is that wage claims can extend beyond the direct employer. So it's important for us to look at the power to hire and fire, whether there is supervision and control of employee schedules and work conditions, and who determines the rate and the method of pay. If that is a joint determination or if somebody other than the direct employer is making those determinations, and where employment records are maintained. And that's, again, the handbooks and policies, who's writing those, how those are being delivered to the employee. All of those types of things are factors that the court will look at in determining joint employment, which could allow for another party other than the direct employer to be liable for a wage claim. Now, this one, the SJC actually denied further appellate review on it. So this should be where we're at. Anything you want to add on that case, Sasha?
Yeah, just the general concept, right? That in Massachusetts, as Monica pointed out earlier on, we have this very strict set of potential liability that comes from violation of the Wage Act, right? So it's very important to keep in mind if that Massachusetts takes very seriously what needs to be done for proper wage payment, and that responsibility for that rests potentially with various people and entities that may be involved in an employment relationship. Another aspect of that I always like to mention too is, the statute has direct liability for Wage Act violations for the officers of the company and for those having the management of the corporation, right? So just because you personally did not, for example, fail to pay somebody's final pay, that doesn't, if you have the management of the corporation, you may well be liable for that. And the same to Monica's point, if it may be structurally, in terms of the corporate setup, it may be a different entity, but if in fact it exerts control in several of these areas or significant control even in potentially even one area, the test may sway the court in favor of finding that the other entity has joint employer liability.
Right. So those were the 5 cases that we wanted to highlight for you today. And then there are some other labor and employment issues from this last year that we also wanted to talk about.
Yeah. So the first I wanted to mention is the sort of annual reminder about the Massachusetts Paid Family and Medical Leave Act. Every year in, I believe it's October, the agency, the Department of PFML, issues what the contribution rates will be for the following year. And so the good news for frankly everyone is that this year the rates are unchanged in terms of how much an employer is expected to pay in or withhold on behalf of an employee if you're a sufficiently large entity. And the other good news for employees is that the weekly benefit does nevertheless increase. So those are the changes. The one thing Monica and I wanted to make sure we cover is just as a reminder that by December 1st, I guess, or 2nd of every year, employers are supposed to notify current employees of the changes for the following year. So I haven't done it yet. better late than never, so do it. But in any case, good idea to set a reminder to make sure that you're looking out for what the rate is in November of every year and are ready to issue those notices. I think that was it.
Right.
So for the other update I wanted to mention is the unemployment costs. So this is not so much an annual change that happens, but it is a trend that's been happening recently, which is that the Department of Unemployment Assistance is anticipating continued increases to the expenses to the fund. And that is resulting also in employers being, all employers across the Commonwealth being moved up in the schedule in terms of what the contribution rates are. So this is different from an experience rating changing where, you know, if you've had a number of separations, the employer may have their own rate change based on the fact that multiple employees are tapping into the funds. This is something that is affecting everyone. And it's, you know, fairly significant effect, as you can see on the slide, right? It's going to go, the percentage increase is going to go, excuse me, the percentage is going to increase from, you know, in the range of 0.83 to 4.6% to all the way to 1.2 to 6.7%. So it isn't anticipated to go in that direction, and that change will happen gradually. So between now and 2028, but something for employers to keep in mind that this is on the horizon and hopefully will help with some long-term planning.
Okay, the next thing I wanted to talk about are a couple of different guidelines that have come out recently in the last year. So the Massachusetts Commission Against Discrimination, the MCAD, recently published guidelines on harassment in the workplace. These specific guidelines are almost 50 pages, and they cover a wide range of different topics. But we wanted to put together a few of the highlights of what those guidelines say, things such as harassment outside of the workplace is also actionable if there's a sufficient link with the workplace or employment relationship. Online harassment, which is becoming, you know, more prevalent, obviously, on social media, other virtual platforms, that can also be actionable. And so it's important to monitor that as well. And that there can be intersectional harassment, so based on membership in more than one protected category. So it's important to look at that. And there are some guidelines explained in the fairly long guideline that was published in July on these issues. And there was also some mention of the harassment policies that are required. So we wanted to put that reminder out there that employers are required to implement a sexual harassment policy. And now there's also a recommendation from the MCAD to have a policy that covers harassment on all the basis of all protected categories. So while the law does not require employers to adopt a workplace policy specifically against protected class harassment, it is now strongly encouraged. The commission recommends that employers implement a general anti-harassment policy aimed at eliminating all protected class harassment in the workplace. So those were a few things that were noted. And so I put both of the links there that will be in this PowerPoint to those guidelines on harassment in the workplace and anti-harassment law in the workplace. Is there anything you wanted to add about that, Sasha?
Yeah, thanks. Just a quick call out that Massachusetts is very much in line with federal EEOC on this matter. The EEOC also issued guidelines not too long ago, and they also talk about things like, you know, just because it happened outside the workplace doesn't mean it's not harassment that may result in employer liability. Same with, you know, potentially harassment on other media. This is not so much new necessarily. I think those of us who have been working with employers on these kinds of issues or providing trainings for a while have, you know, regularly talked about the fact that, you know, harassment on social media is still harassment, and it's still not something that the employer should tolerate. But it's a good reminder to see it in these very specific guidelines and understand that even more than before, presumably the MCAD will be looking at these issues.
Right. So still on the topic of guidelines, as generative AI is being used more and more, we're seeing those guidelines come out. So the Massachusetts Attorney General issued an advisory to employers on AI use. And then also the Department of Labor in October issued an advisory as well. The Department of Labor's advisory is fairly extensive, and it's in line with the executive order requiring those guidelines to come out. So I wanted to focus on the guidelines that are applicable to the Commonwealth and Massachusetts. This is to Commonwealth agencies and offices, but it helps provide others with guidance as well. This is for, again, generative AI use. So that's generating content through the use of AI, creating material through the use of AI. And that's whether you feed material to the AI or not. So sometimes it's that you upload documents and then have the AI create something from those documents. Sometimes it's that you're typing in some type of request for it to generate a form, a document, something of that nature. And so the guidelines just remind us of some of the issues that come out when we are starting to use generative AI, which is something we can't ignore. We know that's definitely going to happen. It's going to happen in the workplace in a number of different ways. So as we should know, fact checking these AI is very important. Bias reduction, and there's a requirement for human review and verification to make sure that the information there is correct, that the AI didn't misinterpret something or hallucinate something. A human component is definitely necessary. While AI can help us in doing a lot of things in the workplace, you can't rely on AI alone. And then when we are using AI, we need to credit AI generated content. So that's another reminder in the guidelines is disclosure of when AI is used. And there's also a lot of privacy and confidentiality concerns. So there's a reminder to limit the use of personally identifiable information when using AI. AI could potentially do the same thing without having that personally identifiable information. So there are ways to get around that and protect that confidential information when AI is being used. And along with that privacy, disclosing to people when AI is being used is very important as well. So that's covered in the guidelines. And then compliance with policies and regulations. There should be clear standards in place, and there's a recommendation from Massachusetts that AI accounts should only be used through a specific office or company, and it's important not to mix that with personal accounts as well, for a number of reasons, for privacy and for tracing, and just keeping the AI use contained is important. So while someone might use a personal account for AI, have a separate personal account. Once they start linking that in the workplace, that could create problems as well, definitely. So there has to be a choice of if the company is using a specific vendor for AI, what is an approved vendor, and is that vendor being used through the employer versus an individual using AI separately. So there's a lot to consider as far as the guidelines go for that. I think it's an area that's definitely developing as well. And so when there's discussion about procurement of generative AI software and services, and there needs to be some type of oversight in how that's being selected as well, because a ton of new companies are coming out with ways that we can use AI. And different products and software. It's important to vet those and make sure that you understand how they use it. Is it open source? Is it closed source? There's a number of questions to ask about AI use. And both of these guidelines also highlight how this is an ongoing evaluation. These guidelines should be continuously updated as this area develops. And What was interesting too for the Massachusetts Attorney General's guidelines there is that they've established an AI sandbox for safe testing of their AI. So the Executive Office of Technology Services and Security designed a safe and secure testing environment to be used. So I think that's really showing the adoption of AI and what it can do, but definitely being cognizant of the potential pitfalls that can happen if it's not used ethically and with, the forethought about the concerns that could happen. So that's the Massachusetts standards, and the Department of Labor's guidelines listed 8 core principles to look at. And some of this overlaps, but this was focused on workers a bit more. So centering worker empowerment by ensuring that workers, especially those from underserved communities, are informed and actively involved in the design and deployment of AI, as well as the oversight. What happens sometimes is a bias in AI use. So that's highlighted in these as well. Ethic development of it, establishing a governance and human oversight, transparency about the use, make sure that people know when it's being used, and then protecting labor and employment rights when you're using that, and making sure that there's no violations of the rights of employees to organize, and their protections as well with that, and having this enable the employees and help the employees support the workers that are affected by AI. So if you're using AI, I think it's a good idea to look at both of these guidelines and develop a plan that works best. So, yeah.
Yeah, I agree with that. And it also just calls to mind that if you haven't developed an generative AI usage policy for your employees, it's probably a good idea to think about that as well, as a potential tool in your arsenal for handling employee potential misconduct, right? So either disclosure of confidential information and trade secrets, or as we talked about a minute ago, harassment, bullying, that kind of thing. Great. All right, well, we're almost at the top of the hour. If anybody has any questions that they would like us to try to answer in the last few minutes we have left, we'd be happy to do that. And otherwise, in a moment, we will turn to the slide that has our COV codes, but just wanted to make sure you all have our contact information in case any of what we talked about sparks your curiosity and you'd like to chat more with either of us about those issues. So, seeing no further questions, we will share the CLE codes, SHRM and HRCI activity codes, and these will also be provided in the materials you'll get after the recording is posted. Thank you all for joining us for this presentation. Monica, thank you so much for your work on this, and we wish everyone a great rest of the year 2024.
Thank you. Thank you, Sasha.